My Lords, I was moving on to a set of further documents and going as quickly as I can. But before I do so, I think it's only fair for me to just point out to your Lordships the evidence that Mr. Gollitz gave to the judge at first instance about Mr. Ford's connections with CSM and indeed his own further connections. If I could invite the court to pick up the supplemental bundle 3, tab 107, page 2037. We've already looked at a couple of these paragraphs already. This is in the context of the heading CSM and Colm Smith. Your Lordships have read 27 and 28. 29, I think I've shown your Lordship the first bit of it, but I think it's important that your Lordship sees what Mr. Gollitz said to the court below. Line 4, this means that neither VDHA nor I have any reason to prefer CSM over any other supplier of financial products. So it's just another financial supplier like any other. And your Lordships will obviously weigh that against the material that your Lordships have seen and will see. We go over the page to 31 where he deals with Mr. Ford. Paragraph 31. I know that Ford has discussed investment opportunities with Mr. Smith. I do not know whether he has provided any kind of remunerated services to CSM, but I do know he's conscious of he's not authorised by the FCA, etc., etc. And again, it may be your Lordships take the view that on any view by reference to these new documents, that is a grossly dishonest piece of evidence at paragraph 31, given that we know Mr. Ford appears to be pulling the strings for CSM to Mr. Gollitz's knowledge. And one wonders, just going back to the Mr. Schmidbauer's prying eyes when he raises questions about VDH's connection with CSM. The first person Mr. Gollitz runs to is, hey presto, Mr. Ford. And I'd be very interested to hear what my own friend's explanation of that is, if he has one. My Lords, that's what I wanted to show your Lordships in that. I go back to and I'm taking this as quickly as I can, conscious of the time. My Lord, we are in the general category of documents evidencing the conspiracy, and of course I'm not seeking your Lordship to make any final findings, matter for the Scottish courts. I asked your Lordship to go first to document 20, page 255 of the Land Marshal bundle, tab 9, where we were. And I'm going to show your Lordships a series of documents now which really need to be taken and read together. They all date to a particular window of time, which is the window of time when Mr. Smith is negotiating in Dubai. And of course, on VDH's case, is merely going through an elaborate and dishonest charade, because he, of course, is Mr. Tahir's minion, and so on. Now, we start at 255. This is a communication between Mr. Duthie and Mr. Ford. Adam says this: Michael is trying to contact me, but I am with Nasser and Colm, so not able to take his calls. Remember, your Lordships, remember Michael Gollitz's evidence at Paras 60 and 61, which I read out to your Lordships before the short adjournment, where Gollitz professes supreme and blissful ignorance about what on earth was going on in Dubai. Nothing to do with me, says Mr. Gollitz. Apparently he's desperately trying to get in touch with Mr. Duthie. We don't know why. He hasn't helped us. Adam, again, could you please let Michael know that I'm in a difficult position? Will do. Can you talk? And so on. So Adam's very keen to get information to Michael Gollitz, who's sitting in Frankfurt or Munich or wherever his offices might be, and is obviously very keen to know what's going on in Dubai. My Lords, that's document 20. 21 over the page 256. We are now. This is the same day, 8th of December, which is the day that Mr. Smith arrives in Dubai. Gollitz writes to Smith, copying in Mr. Ford. I hope this message finds you well and you will have good news out of Dubai today. Would you be interested to launch the attached strategy? Now, what on earth is he talking about good news out of Dubai? We're not told by Mr. Gollitz in his witness statement in response served on Friday, but what this does demonstrate, and maybe your Lordships don't need to come to a final conclusion on that question, what it does demonstrate is that the proposition which is loud and clear, front and centre in his witness statement, I knew nothing about what was going on in Dubai, nothing to do with me, I was getting on with my own business, is obviously false, we respectfully suggest, and at least arguably false. Para 256, page 256. The next document, my lords, is document 23, which I wanted to show you, and that is a document which we find at page 276. We're now on the 9th of December, the next day. Further communications between Ford and Smith, back and forth. Bottom of the page, Stuart says, Colm, give me a call, re-CSM. Re-CSM, says Ford. Colm replies, I read it, whatever it is, we don't know. It was instructed where I got here, the details seem to be correct. The only person that can save Michael is Michael. Despite what has been said about contact, Michael needs to speak to NASA and resolve their issues. I'm a helper, not a wrecking ball. Everyone knows that, including Michael. Again, these are somewhat obscure messages from our point of view. They're nothing to do with us, of course. We weren't copied in on them. But what they do show is Michael Gollitz's profession of ignorance about what's going on in Dubai is just not true, with respect. That's 23. And then finally, 26, which is at page 279. Where Colm Smith writes, I presume, to Mr. Ford. It is at page 286, suggests that. I'm flying out this morning. This is him leaving Dubai on the 18th, and everyone accepts he left Dubai on the 18th. It's been a shit show, but this is a perfect opportunity for Michael. I'll call you when I'm back. Again, precisely what that means is obscure, but what it sure does tell us is that Mr. Gollitz's professions of ignorance are obviously and at least very arguably false. And my lords, and Mr. Smith Mr. Gollitz doesn't help us on this in his, I don't think in his witness statement in response. My lords, I then move on, so that's events from December 2020. I then move on back to February 21, back to document 31, which you have looked at already in a different context, very briefly, page 287, I should say, where we've got Gollitz writing to Ford on the 15th of February. Your lordships have looked at this in the context of the reference to our new business at paragraph 3. And then we have this a bit further down. We haven't heard anything from the Mex Securities side. Not clear what that means. We haven't heard anything from Gibson Dunn regarding the potential claim against VDH. So he's obviously well aware that there is a claim against VDH brewing, and he's obviously well aware that the reason for that claim would be because he pulled the rug from the JV 2 months earlier in his communications with Mr. Nasser Tahir in early December. And just, my lord, pausing at the phrase, we haven't heard anything from the Mex Securities side, it is apparently Mr. Gollitz's evidence that having been desperate to redeem and extract funds from the joint venture from the issuer in early December, absolutely desperate, 2 emails, phone calls, redemption requests, all coming in with the space of a few days from the 1st of December to something like the 4th or 5th of December. Absolutely desperate. Then redeemed, then try to bring out everything because he didn't trust my clients anymore. He says he knows nothing what happened in the next 2.5 months. He had no contact with them. The first he knew of any further difficulties when he hears about the Luxembourg claim. Well, that makes no sense on its own face. But here we have him showing an interest in what's going on with Mex Securities, and he doesn't vouchsafe us any explanation in his evidence, I don't think, as to really what he meant by that. He does refer to this document in paragraph 14 of his witness statement, but nothing on that particular phrase. Of course, we're looking in from the outside, my lords. We can't assist too much other than to point to these documents and say, on the face of it, they raise huge questions, and on the face of it, they suggest that Mr. Gollitz has been very far from truthful to the English court below in his evidence in the 16th of November. My lords, I then turn to documents which you've not yet seen, which is 33 and 34, page 293 onwards. My Lord, one has an email from Smith to Ford at 293, dated the 19th of February. But we have exactly the same email forwarded to Mr. Gollitz at page 295. So let's concentrate on the one at 295. Forwarded by Ford to Michael Gollitz with the words from Colm. So the underlying material is from Colm, but is now being sent by Ford to Mr. Gollitz. And there's a variety of materials which I don't think I have time to really take your lordships through in detail. But if we go to a third of the way down the page, we can pick up some quite interesting material here. Multibank has been demanded by Mex Securities lawyers in Luxembourg and the BVI to return account balances, right? And we know that certainly Mex Securities lawyers in Luxembourg wrote a letter, I think, on the 6th of January, and the BVI lawyers wrote in late December, making demands. When the funds arrive, Mex Securities will carry out a mandatory early redemption. This apparently is the company Mr. Gollitz thought was in my client's pocket. And then a bit further down, Slava has been advised not to have too much external correspondence with anyone. This includes VDH, and so on. And then this, the end goal is to return funds to Luxembourg and redeem Michael's investors. I am fully in support of Michael and the objectives of VDH. This is the man who apparently is my client's stooge, Mr. Smith, writing to Ford, who's copying it to Mr. Gollitz. I'm fully in support of Michael and the objectives of VDH. There is only one party working against VDH and the investors, and that is NASA and his multibank, and the targeting of them is the objective of the lawsuit. Now just pause there, my lords. It is Mr. Gollitz's evidence in his witness statement that he knew nothing about the Luxembourg proceedings rather, until after they were issued. He wasn't involved with them, nothing to do with him. The lawsuit being referred to there can only be the Luxembourg claim, which was issued but 11 days or 12 days later. And apparently it's a lawsuit brought in support of Michael's objectives, but he knew nothing about it. We can't, this is not to be borne, my lords, this evidence.
Do we know who Max is?
We do, my lord. It's a very good question. Max is Monsieur or Maître Mallier, who is a Luxembourg lawyer who caused the proceedings in Luxembourg to be issued on the 2nd of March. We must look at Mr. Gollitz's response on this, my lord. It's tab 12 of the bundle, and we're now at paragraph 16, I think it is. Yes, 16, page 521 of the bundle. Mr. Gollitz says, I can see that this is the document we're looking at, open at page 295, refers to a lawsuit in Luxembourg. I do not think that I knew that the Luxembourg summons was being contemplated at this time. That's consistent with the evidence he gave back in November, which he knew nothing about it. However, as I explained in my third statement, I did know that Luxembourg lawyers had sent demands for repayment. I expect this is what I thought was being referred to which the vernacular answer may be, come off it, Mr. Gollitz. Let's get serious. Let's return to planet Earth. The letter on the 6th of January was a single-page letter making a request for a redemption or return of funds. The idea that on the 19th of February, when Mr. Gollitz read this email from Mr. Smith, he thought that was a reference to that single letter is not to be borne. What this demonstrates, my lord, is one of those rare documents you get in a conspiracy case where the truth is laid bare in all its glory or inglory. This is the workings of the conspiracy exposed on a bit of paper. It's always been my client's case, and they feel somewhat vindicated now they see this letter, that the Luxembourg proceedings, those crazy proceedings alleging economic violence and alleging golden cages and alleging that he wasn't allowed to leave the country until he signed his name on the settlement agreement. I should say a trip which Mr. Mr. Smith, I don't think it's contentious, he arrived in Dubai with his girlfriend and a friend of his who came along for the ride. Some golden prison. It is my client's case, as your lordship may have seen in the papers, that the Luxembourg proceedings were part of the conspiracy to renege on a settlement that had been freely entered into. They were instituted conspiratorially between the various conspirators. They failed because they were the subject of a anti-suit injunction in the BVI. And then they went back to the drawing board and started off some new proceedings in the BVI a couple of weeks later. Here we have laid bare, my lord, between three of the central conspirators, as we would put it, the purpose of the lawsuit is to assist Michael and the objectives of VDH. This is not a lawsuit issued by Mex Securities for its own private reasons. It's issued as part of a wider campaign which is ultimately to support Michael Gollitz and the objectives of VDH. And the answer that is given at paragraph 16 of Mr. Gollitz's witness statement doesn't come close to providing any kind of explanation. And my lords, your lordships will immediately recall document 63, which we've already looked at in a different context. We can just whiz straight back to that very, very briefly, page 365, because one has to look at these things in context and connect them together. Your lordships remember that 3 years later, or 2 years later, 2.5 years later, we have Mr. Smith telling Mr. Ford, who then tells Mr. Gollitz to put it in a letter, we, CSM, have been engaged in lawsuits against Multibank from 2021 to date. Page 365, little Roman 4. And again, Mr. Gollitz refers to this document in his witness statement. I'm not sure I showed it to your lordships before. Paragraph 19, page 522 of the bundle, where Mr. Gollitz contents himself with saying, I do not know exactly what Mr. Smith had in mind when he said, thereafter we've engaged in lawsuits. The phrase I've just quoted from page 365. And then he says this, perhaps the reference to lawsuits is intended to refer to the Luxembourg summons, although I stress I had no full knowledge of it. I do not know what other lawsuits he regards CSM as having been engaged in. And then, my lords, bear this in mind. No doubt your lordships will consider this sentence very carefully. I suspect Mr. Smith's language is exaggerated. Make of that what your lordships will. What we don't have back is Mr. Gollitz writing back to, because remember this was sent to Gollitz eventually in that document at page 368. This is the document sent to Schmidbauer. We don't have Gollitz writing back saying, guys, you're going mad. What are you talking about? What's all this stuff about lawsuits and CSM? And et cetera, et cetera. No, instead he tries to sack Schmidbauer 5 days later. My lord, that's document 63. Now, my lords, I'm conscious I spent quite a lot of time on these documents, but I felt it really is my professional obligation to do so and to explain to this court why they are so absolutely critical to this case. And we respectfully do not invite your lordships to come to final conclusions. Of course your lordships shouldn't do so. And much of my learned friend's submissions seem to be directed at the completely false target, which is saying you shouldn't, we need more time to think about these. We might, who knows what else is in there. We're not asking your court lordships to come to final conclusions. We're merely saying the evidential landscape has changed absolutely fundamentally. And it would be quite preposterous, we would respectfully suggest, for this court, as I suspect Mr. Calfon will invite you to do, to simply put these documents out of your mind and pretend that the evidence is as contained in Mr. Gollitz's witness statement, and that evidence is true. That's what Mr. Calfon's eventually going to suggest to your lordships, as I understand it. And we would suggest that would be a pretty remarkable outcome for the court simply to close its eyes to these truths, close its eyes to these devastating documents. No doubt assist Mr. Gollitz and quite understand that. My lords, I have not gone through every single document in this bundle, because if I were to do so, I would be into tomorrow and possibly the next day. And I've only got 3 days. We've only got 3 days. So I have to, as I hope any mildly proficient advocate is obliged to do, try to make it as simple and as easy and as clear for your lordships as I possibly can. The other documents are more of the same in some respects. They show the interconnections between the various conspirators, as we would characterise them. We have set out in extenso in the documents which my Lord the Chancellor didn't have the full document of. That's been handed up. I don't want to take your lordship to it.
Thank you.
Thank you, but I'm not going to take, but we set out in the very challenging circumstances we found ourselves in and under the time pressure we found ourselves in, we've set out so much as we can in that document. My Lords, I want to move on now to two other documents, which are the Sanderson judgments, which of course fall into an entirely separate category. And to remind your lordships very briefly, they were the two judgments handed down on the 17th of May, one in the petition proceedings related to the search order, two in the freezing order proceedings within the underlying summons, which is the claim against all the 12 defenders, including my learned friend's clients. And I've told your lordship precisely the circumstances in which those judgments were handed down. I don't think I need to go through that again. Perhaps remarkably, my learned friends say your lordship should simply not even know, or if you do know, because necessarily you do because of my submission, simply put out of your mind the fact that things have happened in the Scottish proceedings. You should exclude them irrevocably and utterly from your lordship's minds, is what is said by my learned friends. And they put that on three bases in their skeleton argument. Basis one is to say that those judgments, which are judgments within the main proceedings, to be clear, in Scotland, we are here simply occupying a subordinate position, as your lordships know. They are inadmissible, not even a weight question, inadmissible before this court. Judgments of the judge in the main proceedings. And they rely on our old friend Hollington and Hewthorne, as interpreted in Rogers and Hoyle. And those judgments are within your lordship's bundle of authorities, which I'm afraid you've got a second bundle of authorities, the Ladd and Marshall bundle of authorities. I'm not going to take your lordship to those judgments because your lordship know them, of course, only too well. But your lordships will remember...
When you say a second bundle of authorities, you actually mean a sixth.
Yes.
I regret that is a fair and plangent point. Yes, I regret. When I... well said, if I may respectfully say.
Just to correct the transcript.
Yes.
Yes. A second, in category terms, I can say, I think, with a second bundle. My lords, the rule...
Well, we look forward to being the very first case in this court for many years when we've been referred to every single authority in the authorities.
No, you're not going to be in that category whatsoever. My lords, Rogers and Hoyle, very well-known case of decision of this court, of course, of a few years ago, that decided that in the context of a trial, when a court is making final findings on who is telling the truth, where the facts lie, then an earlier judgment must be put aside because the question for the judge is, to quote paragraph 40 of Rogers and Hoyle, entrusted to the trial judge alone. Now, we are a million miles away from that scenario. We here in this English court, as I've said, are occupying a merely subsidiary role to these proceedings in Scotland. We are also occupying a merely interlocutory role. No findings are being made. One is merely being asked as a judge, or the courts are merely being asked in this jurisdiction to assist the Scottish proceedings by exercising the extraterritorial jurisdiction that this court is wont to exercise. And my lord, can I just, in fact, invite the court to look at one of the judgments in the main bundle of authorities, which is a case which will be of some assistance generally, I suspect, and a well-known case to your lordships, which is called the case of Refco, decided by Mr. Justice Ricks and then on appeal. And it is at tab 19 of your lordship's bundle of authorities, page 272 of the external pagination. And much of Refco we don't need to trouble ourselves with now, but there is a particular statement of the law by Mr. Justice Ricks at page 277, of the external pagination, 164 of the internal pagination, where, and I don't apprehend that these dicta have in any way been overturned or were dissented from by the Court of Appeal in that case. The learned judge, bottom of column 1, refers to the very famous case of Credit Suisse. This is page 277 of the external pagination. Does my lords have that? Mr. Justice Ricks refers to the famous case of Credit Suisse, which of course has been cited to your lordship and quoted from in the skeleton arguments, emphasises the need, this is 3/4 of the way down column 1, emphasises the need for caution and the subordinate role of the English court in exercising its jurisdiction under section 25. Moreover, since the plaintiffs here have still to show a good case for the grant of a Moravian injunction, they must first meet the 2 minimum requirements of good arguable case and so on. Then we go over the page, and to pick it up at the last paragraph of column 2, in such a case, a court faced with a merely ancillary jurisdiction, if indeed it has any jurisdiction at all in the light of the contractual jurisdiction clause, that's not pertinent here of course, should be especially cautious and sensitive to the informed view of the foreign court concerned with the substantive merits. And that, I suggest, is a proposition that has pervaded the learning and jurisprudence on this, under this section ever since. We can put away REFCO for the time being. We may have to look back at it in a different context. But it just tells us the prism which we should look at these judgments with, these Scottish judgments. They are the judgments of the primary court dealing with the primary proceedings. And of course, my lord, it is suggested by my learned friends, well, we weren't defendants to the petition. Only the Scottish defendants were defendants to the, or respondents to the petition. Well, there are 2 points to make there. The first is the petition was granted in aid of the main proceedings. And we have Mr. Brown's explanation in his opinion and his affidavit on the role of the petition and its interconnection with the summons, the main bit of originating process. But secondly, what is indubitably true is that Mr. Gollitz and VDHAG are parties to the main proceedings, to the summons, and the second judgment was made within the main proceedings. Now, the order, the quasi-freezing order that issued from Lord Sanderson, was an order that theoretically bit on every single one of those defendants, so far as they had assets in Scotland. As a matter of practicality, it may not have bit on Mr. Gollitz and VDHAG because they did not, as a matter of practice, have assets in Scotland on which the order could bite, because it applies to assets, not to individuals or entities. But they could, if they wished to have done so, applied to set aside those orders as against themselves, and they chose not to do so, presumably for practical reasons, because it didn't really matter, because it didn't actually affect them in any shape or form, because they had no assets in England. In Scotland, rather. But the key point is, the second judgment, which, as your lordships will have seen, cross-refers and draws from the first judgment, is a judgment against all, in respect of the proceedings in which all the defendants are parties. And it is a judgment that holds, as I would suggest, that there is a good arguable case made out by MGWL. Not against just defendants 1, 2 and 3, but not anyone else. If one reads that judgment, he is saying there is a good arguable case against, in respect of the claims pleaded, and therefore I'm going to uphold the warrant of diligence, i.e. the freezing order. So Rogers and Holland has got literally nothing to do, and Hollington and Hewthorne has got literally nothing to do with this case. The second submission that is made against me is that, it's obvious that Lord Sanderson was not exercising a good arguable case test or applying a good arguable case test. And they say, well, look at what he says in the petition judgment. And we say, well, we make our submissions on that, but we say this is an arid debate. Because if we look at what he says in the summons judgment, the judgment against you, even if you didn't challenge it, that order, if you were to bring, Mr. Gollitz was to buy a holiday home in the Highlands, then it would apply, it would bite on him then and there. Whether he's inclined to do so or not is another matter, I don't know. But the judgment in the summons proceedings, in terms, my lords, applies the standard of good arguable case. And it in terms does so by reference to Scottish authority. And let me just explain the point, because it goes much wider than this ladder marshal question. If your lordships please turn to the ladder marshal judgment, bundle, and go to tab 11, forgive me, tab 10, and go to page 480. It's a very short judgment because it cross-refers to the petition judgment. He sets out the burden on the pursuer, my client, at paragraph 1, which is to show a prima facie case on the merits and a real and substantial risk of enforcement, blah, 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 and sets out what the case is that sets out the test, Gillespie and Toondale, which I'll come back to. And he then sets out the arguments that have been put forward by all the parties, and the pursuer says, paragraph 3, line 5, question remained whether a good arguable case had been made out by the pursuer. The defendant says no, it hadn't, for various reasons, and the decision is at 5 and 6. And at paragraph 5, for reasons which are well understood and canvassed clearly in Gillespie, the pursuer requires to surmount the substantial hurdle of setting forth a good arguable case and not merely a colourable one. Now, my learned friends suggest that Lord Sanderson uses the phrase good arguable case there in the sense that it doesn't mean good arguable case. My understanding of the way judges work, whether in Scotland or England, is they use words pretty carefully. But apparently that's my learned friends say, no, good arguable case is not used there in the sense of good arguable case. It's used in some lesser sense. So we have to, in order to chase that point down and give it its quietus, we say, well, look, what's the case that actually sets out the test, which Lord Sanderson endeavoured to apply, Gillespie and Toondale? And we do have that in the bundle. Apparently it's quite a well-known case in Scotland. If we go to tab 3 of your lordship's ladder marshal bundle, your lordship will see the case before Lord Johnston, decided in 2005. And I think we do no better than go to paragraphs 12 and 13 of Lord Johnston's decision, which I don't propose to read out to your lordships, where it's page 28 of the external pagination, tab 3, bottom of the page, paragraph 12 to 13, where your lordships will see that the law in Scotland, as applied by Lord Sanderson in this case, just 2 months ago, is that the test for the Scottish equivalent of a freezing order is, lo and behold, the test applied in English law in relation to moreover injunctions. There it is, in the quotation, top of page 29. So the point is simply a bad point, and we shouldn't be wasting our time on these points, my lord. We've got better things to be doing than arguing these kind of issues. And I'm having to do so because my learned friends are insistent that these judgments simply should be ignored. My lord, there's a further case which I need to show your lordship, which again will have double work and double assistance to your lordships, which is a very well-known case called Motorola and Uzan, and which this applies to the first point my learned friends make, and it may apply to some of their other points as well. So let's look at it in one single go. Motorola and Uzan, of course your lordships know that case very well. It's bundle, main rep authorities bundle, tab 21. Decision of the Court of Appeal, of course, in 2003. And I'm just going to go very quickly to paragraph 102, which is, I think, a paragraph my learned friends cite in another context. Page 354, external pagination. I just mark, but I'm not going to read it out because I haven't got time, but mark 102 because my learned friends draw some sort of comfort from it. But then go to paragraph 105, And I just invite your lordships to read out paragraph 105, read to themselves paragraph 105, because it just explodes the notion that judgments of the substantive court, which has substantive jurisdiction over the substantive case, are to be ignored, because it's precisely the opposite of what Lord Justice Potter, I think it was, said there.
Yeah.
Your lordships may think that's only just, with great respect to Lord Justice Potter, clear common sense, but not to Mr. Gollitz and VDAG, HAG, who says no, you've got to ignore it. You've got to ignore what the actual substantive court has decided. And we say the fact that the substantive court, having looked at all the papers, having considered a vast amount of evidence, having heard 3 days of argument, vigorous argument, didn't include argument from VDHAG because they chose not to attend, Mr. Gollitz, they chose not to attend, matter for them. The idea that a reasoned decision by Lord Sanderson is just irrelevant and inadmissible. Let me just make, it makes, if the answer was, if that was correct, just turn the English law into a laughing stock in my respectful submission. My lord, those are the broad points that are made against me on the supposed inadmissibility of Lord Sanderson's judgments. They also say, as a sort of final point, oh well, we haven't had an opportunity to put in Scottish evidence on the question. We don't need Scottish evidence. We know what the law is. It's there in the law reports. And in any event, my lords, well, what is really surprising is that Mr. Brown, the junior counsel, put in evidence at first instance before the English court, where he sets out, and it's in his affidavit, tab 113, page 217 to 219, I don't take your lordships to it, paragraph 7 and 13, he sets out that the test the Scottish judges apply when it comes to freezing orders and search orders or the equivalent thereof is, in broad terms, the English good arguable case test. And that was there, no one contested that, no one put any evidence in from the other side saying Mr. Brown has misunderstood the Scottish law. That was the evidence, uncontentious evidence before the court below. So this idea that, oh, we need to have more time to put in evidence, they disputed that. They'd have put in evidence before Mr. Tinkler, but they didn't, because they didn't dispute it. And in fact, the only point that was made by Mr. Calfon below about the ex parte decision, and I quite accept that there's a difference between an ex parte decision and an inter partes decision. The only point made by Mr. Calfon was not, it wasn't admissible, it was that, quote, substantial weight should not be given to it. And the judge agreed with him. The judge agreed that only marginal weight should be given to an ex parte judgment. But we've now moved forward, my lords. We've now actually had a 3-day argument about the question, heard vigorous arguments, massive amounts of evidence have been put in, and Lord Sanderson has agreed that in fact, a good arguable case was established by my clients. And not a good arguable case about some little sliver of the case against Ford or McCormack or whoever, but generally because it's a single claim. It's a claim in conspiracy against all the alleged conspirators. You don't turn it into little silos. And that's not how Lord Sanderson dealt with it in his judgments, as your lordship has seen. So I'm going to sit down, my lords, now. I'm sorry to have taken so much time over these points. My lords, those are my submissions on the Ladder Marshall applications. The other two documents are not contentious, so I don't need to trouble your lordships with that. I would invite your lordships to admit the evidence into this appeal, and your lordship will have seen that, of course, a lot of the submissions that I might make in at some later stage in my submissions and in the case have already been to some extent foreshadowed in those submissions. So I hope my submissions have done at least some double work rather than spending a whole half day and more on an interlocutory application within this appeal. So, my lords, unless I can assist you any further, those are my submissions on the applications.
Right.
My Lord, just before I start, my learned friend made some submissions about the timing of any Scottish trial. Nobody knows, so it's all guesswork, but I'm told it may well be 2026. My Lords, before dealing with the meat of the application, I just want to set out a bit more background to this dispute. Your Lordships have heard some isolated references to the chronology, which came before the Scottish proceedings in my learned friend's submissions, and I thought it'd be helpful to set it out a bit more fully. In 2016, VDHAG arranged for a series of notes to be issued by an entity referred to as Oaklet. Actually, there are several relevant entities in the Oaklet group, but to keep matters simple, I'll refer to them all as Oaklet. The proceeds of the note issues were managed by a man named Mr. Moser, with a view to generating returns from foreign exchange markets. And one can see that in Mr. Gollitz's second statement, paragraph 34. For your Lordship's note, the bundle reference is Supplementary Bundle, tab 107, page 2038. And some of the funds invested in the notes were from VDHI, which funds VDHAG managed. Mr. Moser arranged a meeting between Mr. Gollitz and Mr. Taher in Beijing in March or April 2017. Accounts differ. MGWL's case is that Mr. Moser had performed poorly and that Nasser Tahir agreed to contribute a sum of money to the pool of assets managed for the note holders to restore some of his losses. The quid pro quo was that the assets would be traded on multi-banks platforms, leading to profit for MGWL. And for that, one can see Mr. Taher's affidavit, Supplementary Bundle, tab 55, page 589. Exactly how much was contributed and how much profit it was said would be earned varies substantially depending on which evidence put forward by multi-bank one consults, but it doesn't matter for immediate purposes. Multibank claims that this agreement gave rise to a joint venture between it and VDHAG. My clients do not accept that, but in my respectful submission, this is a somewhat sterile debate. The term joint venture is not a term of art, and describing a relationship as a joint venture tells one nothing about the rights and liabilities between the parties thereto. It is also of only tangential relevance to the questions before this court. So I propose to pass over that particular rabbit hole. Multibank then says that there were further meetings between Mr. Gollitz and Multibank in Frankfurt in May and July 2017. This is again from Mr. Taher's affidavit, Supplementary Bundle, tab 55, page 592 to 596. Over the course of these meetings, they said that it was agreed that A, Multibank and VDHAG would create a new index, the Multibank Index, to invest the proceeds of notes issued in. Multibank paid for the legal fees for this, which they say cost 500,000 euros. Multibank purchased an asset management company called Mex Asset Management to promote the sale and distributions of the notes at a cost of 510,000 euros, according again to Mr. Nasser Tahir, paragraph 173. This is again in the Supplementary Bundle, tab 55, page 597. And Mr. Tahir also says he purchased about 3 million euros of notes personally. That's paragraph 169, so page 596. There were then plans to make a public offering of notes tied to the multi-bank index. To that end, Mex Securities was incorporated on the 30th of July 2018. And the reference for that is Supplementary Bundle, tab 52, page 468, and the date is at the top of that page. And nothing came of the public offering. The parties disagree as to whose fault that was, but again, we don't need to go into that right now. In late 2019, a dispute between Oaklet on the one side and Multibank and VDHAG on the other side arose, and this prompted litigation in Australia and an abrupt cessation of trading, causing the note holders' funds to drop substantially in value. And it was in September 2019 that Gollitz met Mr. Ford. And my lords, my own friend poured opprobrium on Mr. Ford, repeatedly referencing his fine and lifetime ban, seemingly to attempt to taint Mr. Gollitz by association. The only reason why Mr. Gollitz met Mr. Ford was because Mr. Ford was a consultant to Multibank. And Mr. Taher, who knew of Mr. Ford's history, arranged an introduction and suggested that they work together. And one can see that in Mr. Gollitz's second statement, paragraph 24. That's in the supplementary bundle, tab 107, page 2036. My lords, my learned friend repeatedly asked why Mr. Ford was on documents related to multi-bank business. The evidence is that he was a consultant to Multibank at the time. And I'd refer your lordships to the affidavit of Mr. Taher, paragraphs 58 to 59, supplementary bundle, tab 93, page 1857. In November 2019, Multibank presented Mr. Gollitz with the letter of undertaking and demanded that he sign it. And that's set out in Mr. Gollitz's statement, paragraph 44, supplementary bundle, tab 107, page 2040. And a copy of that letter of undertaking is in the bundle. I'd just like to take your lordships to that. That's supplementary bundle, tab 6, page 51. So, my lord, this is the letter of undertaking dated the 26th of November 2019. As I say, supplementary bundle, page 51. And by its terms, Mr. Taher agreed to make a €5 million ex gratia payment for the benefit of all note holders for the purposes of increasing the equity value of the notes. And Mr. Gollitz agreed not to advise clients to withdraw funds from the notes, not to withdraw funds unless compelled to, and to do everything that they reasonably could to prevent any outflow of equity. My lords, Mr. Gollitz's evidence is that he doesn't know whether the €5 million was paid as promised, but he felt dependent on multi-bank support and obliged to sign. And for that, one needs to go to, I won't take your lordships to it, paragraph 44 of his statement, supplementary bundle, tab 107, page 2040. In April 2020, a note swap was effected, whereby the note holders' funds were transferred from accounts at Mex Australia in Oaklet's name to accounts at Mex Australia in Mex Securities' name, and the notes issued by Oaklet, held by note holders, were replaced with notes issued by Mex Securities. And for that, one can see that in MBFX's defence in the BVI, supplementary bundle, tab 81, page 1508. And Multibank's evidence is that in order to complete the note swap, Mr. Taher was asked to invest a further €2,447,385 and to spend a further €2.5 million purchasing the notes of one of the investors. And one can see that in Mr. Couture's evidence, which is quoted by Mr. Justice Jack in the BVI, in supplementary bundle tab 52, page 476. And this prompted a demand from Multibank that Gollitz sign what's called the deed of affirmation on behalf of DHCJ. And if I could just take my lords to that, the deed of affirmation is in the supplementary bundle tab 52, page 276. Sorry, it's not. It's in the, sorry.
147.
147, I'm grateful.
Sorry, what page?
It's page 147.
Tab 11.
My lord, yes. So this is the deed of affirmation by its terms, VDHAG acknowledged financial support in the amount of at least 10 million euros from Multibank. And VDHAG undertook to ensure deposits exceeded withdrawals from the note holders' funds, not to advise note holders to withdraw funds, and to use its best endeavours to introduce investment into the new notes. And just whilst on the document, your lordships will note that right at the end of that document, there are governing law and exclusive jurisdiction clauses in favour of Luxembourg and or Germany. Now, following the note swap, the Oaklet litigation settled on the 15th of September 2020. And one can see that in the judgment of Mr. Justice Jack in the BVI Supplementary Bundle, tab 52, page 481. On the 14th of October 2020, VDHI's regulator, the CSSF, raised a number of issues with VDHI. I won't take your lordships to that, but for present purposes, the bundle reference is Supplementary Bundle, tab 13, page 159. Around the same time, between the
trading, that's to do with the trading in gold.
no, it's other matters. I can take my lord to it now if that would assist. So it's at page 159. It may be that some of the concerns are linked to gold, but it's probably better for me just to refer your lordships to the entire document.
Right.
So that's the letter from CSSF to VDA.
Concern about the deficiencies identified by their auditors.
My lords, around the same time, between around the 6th of October 2020 and the 20th of November 2022, and this is from VDHI's RFI response in the BVI, so for your lordship's reference, this is Supplementary Bundle, tab 76, page 1260. Around this time, VDHI discovers that
Page one.
Page 1260. Around this time, VDHI discovers that the notes expose it to gold prices. That was not permitted under the UCITS directive, which applies to the VDHI funds. And so VDHI asked Mr. Gollitz to sell its notes, and when he failed to do so, instructed him to do so on the 20th of November 2020. And my lords, for completeness, VDHI's position is that failure to comply with UCITS is not illegal in a criminal sense, and it did not make any profits illegal, and one sees that from VDHI's response to request for further information at paragraph 51, which is in the Supplementary Bundle, tab 76, page 1251. It appears that in December, Mr. Gollitz attempted to find a workaround to the UCITS issue with Mr. Smith, looking at amending the investments or effecting a new note swap. Can I ask, my lord, just to turn to page 163 of the Supplementary Bundle. So this is an email from Mr. Smith, Colin Smith, to Christopher Brandle, VDHAG, dated the 1st of December 2020. Yesterday we discussed the components of the two indices, specifically the gold-related positions and the qualification criteria of these notes underlying indices for your investors. Earlier we discussed concerns raised by your auditors about the fiduciary estates not being accepted at two separate issuers. Please clarify for us if we need to address the following, and then there are some options set out there. However, if we turn to page 167, my lords, by the 2nd of December 2020, Mr. Gollitz was telling Mr. Smith that he would have to redeem VDHI's notes. So that's page 167. And we can see the email from Mr. Smith to Mr. Slava, I spoke to VDH this morning. The multi-bank indices allow for trading in gold. This is not permitted per certain VDH investor profiles. Despite looking at other potential alternatives, VDH must instruct the redemption of approximately euro 10 million in total from FE2 and FE3. Maybe they can reinvest in a new note without gold at a future point. However, they must do the redemptions before year end. VDH will discuss this in advance with multi-bank. And on the 3rd of December 2020, Mr. Gollitz raised the issue with Mr. Taher, telling him that he had to redeem VDHI's notes owing to recent regulatory changes. And he said that he wanted to work out an alternative product which would resolve the issue, but in the meantime there had to be a withdrawal. We can see that letter at page 169. So this is a letter from Mr. Gollitz to Mr. Taher dated the 3rd of December. One sees, my lords, at the top. Dear Nasser, I hope this message finds you well and you feel better than I do. After our call from last week, the situation has changed and I thought I'd drop you a few lines to describe this. And then scrolling down to paragraph 3 over the page.
Yeah.
And then the worst comes to worst. I was informed by a fund administrator and the auditor that there have been recent regulatory changes and that we're not allowed to hold instruments which have gold included. And we have to sell the position immediately. There's no choice for me to avoid this. The only thing I can do is looking for solutions to come back as soon as possible on different ways. A, we try to launch a note which combines Alpha 2 and multi-bank in one product. This process is running since yesterday, but we cannot estimate if that will really work. B, we launch a new note without gold, etc. And one can see B and C there. And this letter prompted a call between Mr. Gollitz and Mr. Taher later that day. And we can see the transcript at page 172. And in that call, Mr. Taher suggested reversing out the gold trades from the point at which the regulatory change kicked in, leaving multi-bank with some or all of the profits. And
Sorry, where's that?
that is, well, there's certainly a reference on page 173. NASA 0233. No, we can no because we need to know what date it is because I need full details because I'll have to put it on my board. We can reverse all the gold trades. And then on page 176, yes, page 176, NASA 0620. Please send it, Michael. I understand the situation. You know what I mean. We can discuss, we can make a compromise between both, you understand, so they don't lose the whole performance, you understand. And then Mr. Gollitz responded on the 3rd of December 2020. We can see an email at page 178 where Mr. Gollitz tells Mr. Taher two paragraphs, second paragraph, unfortunately the approach you suggested, which did sound nice, is not an option for them. They made it very clear to me once again that we have to sell the notes because of the changes in regulatory requirements and to set up a new note which is fully compliant in the new year. If you want, I can set up a conference call with them to explain the issues. And this was followed on the 4th of December by an email from Mr. Gollitz to Mr. Duthie, which my lords will find on page 181. And in this email, Mr. Gollitz identified the provision in the UCITS directive which was causing the issue. So at that point, it would have been obvious to multi-bank that this was not a recent regulatory change, but had always been an issue. One can see there that Mr. Gollitz identifies Directive 2009-65 EC. And my lord, just on Mr. Duthie, it was repeatedly suggested by Mr. Grant that it was common ground that Mr. Duthie was playing a double game. I don't know what my learned friend means by that, but if the suggestion is that it's common ground that Mr. Duthie was conspiring with Mr. Ford or anyone else against multi-bank's interest, that is most definitely not common ground. Now, on the same day, a letter of demand was sent by Savills on behalf of MGWL to Mex Securities, in which it said that 34 million euros, 34,831,216 euros to be precise, had been advanced by Mex Group and its predecessor on the basis of representations made by VDHAG which were false, and in any event the sums in question were, it was said, repayable on demand. And that letter is at page 182. Yes, so what one can see here, we're instructed to demand immediate payment by Mex Securities acting in respect of its fiduciary estate 1 and fiduciary estate 2, the sum of €34,831,216, the indebtedness being sums advanced by Mex Group to Mex Securities and its predecessor on the basis of certain promises and representations made by Von der Hayt and Co. AG, which have proven false and which are in any event repayable to Mex Group on demand. And for completeness, my lord, Mr. Gollitz does not think this letter was sent to him at the time. And one can see that in his evidence, paragraph 59, which is in supplementary bundle, tab 107, page 2043. And Mr. Gollitz sent an email to Mr. Smith complaining that his transfer requests were not being honoured. Mr. Smith responded to say he was in transit to Dubai. And that is on page 183 of the supplementary bundle. That's the email. And Mr. Gollitz believed that Mr. Smith was travelling to Dubai to figure out some kind of alternative product with multibank. And one can see that, my submission by reference to the previous emails, but also from Mr. Gollitz's second statement at paragraph 60, supplementary bundle, tab 107, page 2043. And this appears to have been before Mr. Gollitz had demanded the return of all of the monies on the basis that he could not trust multibank. That appeared to happen on the 5th of January 2021, and one sees the reference to that at page 255. This was followed by a letter from Mex Securities to VDHAG saying that they would not honour Mr. Gollitz's withdrawal requests. And the letter's at page 184 of the supplementary bundle, and it's clear that this letter was written at the direction of MGWL for the reasons that we've set out in our Ladden-Marshall skeleton argument at paragraph 27, subpara 4. One can see, for example, that Eversheds ask questions on page 186 on behalf of multibank. So, for example, D&E. Also, my lords, in evidence filed in the BVI, multibank described the letter, and I'm quoting from Mr. Duthie's affidavit at paragraph 28, which is to be found in the supplementary bundle, tab 44, page 309, as a letter from Multibank Group's Luxembourg solicitors Eversheds, and Multibank paid for the letter. And one can see that, one can see a reference to payments to Eversheds on behalf of Mex Securities on the list of costs said to have been incurred by Multibank at supplementary bundle, tab 49, page 415. On the 8th of December 2020...
Right, I'm being slow. The letter at 184
yes.
is sent by Eversheds
yes.
to
VDHAG, my lord.
To VDHAG.
Yes.
Acting for Mex Securities.
Yes, exactly, my lord.
But you, by reference to those other references, you say it was actually written by
yes.
Multibank.
At the direction of MGW. Yes, of MGWL.
Yep.
And then on the 8th of December 2020, if I could just ask your lordships to turn to page 188, deed of assignment. MGWL assigned its purported claims to Mex Clearing. And so a copy of that assignment's at page 188, and one can see that the assigned claims are described as loans and other claims in respect of payments made for the benefit of Mex Securities in the total sum of €36,385,509. So that's 2 million more than was demanded 4 days previously. My lords, just in terms of how this figure is made up, it's broken down in Mr. Duthie's first affidavit in the BVI at page 308, tab 44. And could I just ask my lords to go to that? Tab 44, page 308 of the supplementary bundle.
Yeah.
One can see that he said the multi-bank group acting through MGL advanced loans and made related payments to Mex Securities Limited for the benefit of the issuers as
Where's
following.
that? What page is that?
I'm sorry, we're on page 308. One can see paragraph 26. Pursuant to the VDH agreement and based on the representations and promises of Mr. Gollitz on behalf of VDH, the multi-bank group acting through MGL advanced loans and made related payments to Mex Securities Limited for the benefit of the issuers as follows, totaling 36 million. It's worth making the following points, my lords. The cash injection to recover losses suffered in the notes March to April 2017 was before Mex Securities was even incorporated. So how, I rhetorically ask, could it possibly be a liability of Mex Securities? That's 2,621,000. The acquisition of Mex Asset Management was also before Mex Securities was incorporated, and in any event, Multibank retained the benefit of Mex Asset Management. So the purchase price was not a sum advanced to anyone, it was a sum it spent purchasing itself an asset. Likewise, it would have retained the benefit of payments for software and trading, development and software. One can see these are huge. Payments for technology service offices, 8.9 million. Payments for software and trading development team, 6.2 million. The cash injections in December 2019 and January 2019, I assume 2020 was meant, were for the benefit of Oaklet, not Mex Securities, which did not become the relevant note issuer until April 2020. The legal costs of the dispute with Oaklet were not incurred, or not all incurred, on behalf of Mex Securities, which didn't have any interest in the dispute until after the note swap. And none of these are loans. At this time, Mr. Smith was in Dubai discussing matters with Multibank. And, my lords, we have a partial transcript of those discussions, which is at, in the supplementary bundle, tab 93, page 193. And Mr. Grant describes them as hotly contested. No one's ever suggested that these transcripts are anything other than accurate. VDHI, in its claim in the BVI, says that those transcripts demonstrate that Mr. Smith and Multibank were colluding to appropriate the note holders' funds. And perhaps the best thing I can do, my lords, is to take you to what VDHI says about these discussions in their BVI pleadings. I'd ask my lords to turn up.
Before we do that, could you just give me the reference again? You said tab 93, page
193 for the transcripts, page 193.
Sorry,
I'm sorry, I think I
By
may
the
have
time
the
we get
tab
to tab-
wrong, but it's
By the time
definitely.
we get to tab 93, we're way
No.
beyond page 193.
We are, my lord. I'm sorry, but the page number is correct. It's tab.
internal page.
I'm sorry. Yes, it's tab
The
26. Yes,
Tab 20.
it's tab
93.
26. No, I'm sorry. It's tab 26,
Oh.
and the bundle page is 193.
Tab 26, let's have a look at that.
And nobody is suggesting that these transcripts are anything other than accurate.
So which page?
Page 193.
So this is transcript of discussions between Mr. Smith and Mr.
Yes, Tahoe. And I think the best that I can do, my lords, is to take your lordships to, because some of these transcripts are set out in VDHI's pleading in the BVI,
Yeah.
is to take you just to that pleading very briefly, because part of it can be found at tab 58, page 692.
Sorry, I'm speaking for myself. I've not looked at that transcript, but you want us to take us to a pleading what that deals with the transcript?
It does, my lord, yes. It's
Give me the reference again.
It's
Tab
page
58.
692, tab 58.
Thank you.
And my lords, could I ask my lords to read paragraphs 43 to 53? So it's pages 692 to 698. My Lords, in my submission it is clear that what is happening here is that Mr. Smith is assisting Multibank devise a strategy to take the note holders' funds for themselves. And the email referred to in paragraph 53 of VDHI's pleading can be found in the supplementary bundle, tab 28, page 217. And I'd ask your Lordships just to turn to that, please. Tab 28, page 217.
It's 217.
My Lord, I'm sorry, it's tab 29,
Yeah, never mind that.
at
It's
page 217. Yes, my Lord.
This is the claims spreadsheet.
Yes, and so your Lordship can see that Mr. Smith has marked those sums which can be supported by reference to the deed of affirmation in the ref yes, in the over the next page, 218, in the ref in deed of assignment column.
Yes.
And you can also see that well over half of the sums claimed cannot be supported in that way. And on the same day that email was sent, and further to the plan agreed with Mr. Smith, Mex Clearing commenced proceedings against Mex Securities and MBFX. And MBFX is the multi-bank company which held the note holders' funds for €36,385,509.52. And one can see that on page 208. And it is unambiguously a debt claim. One can see the claimant as assignee claims against the first defendant the sum of €36,385,509.52, being a total of the sums advanced as loans by the assignor to the first defendant, which sums are held by the second defendant to the order of the first defendant. Similarly, the particulars of claim are clear that the sums are claimed as loans, and that's at page 213. And my Lords, on the 11th of December 2020, Mex Clearing made an anonymity order, or obtained an anonymity order in the BVI, supposedly to protect itself from the reputational risks of litigation. And as Mr. Justice Jack in the BVI would later remark, one can see the judge's observation of paragraph 33 of his judgment, which is, for your Lordship's reference, tab 52, page 495. Just want to check the page reference. Yes, page 495. Given the case had already settled on terms already agreed, there was no need for secrecy. And secondly, if it really was a straightforward debt collection exercise, where is the reputational risk? My Lords, apparently Mr. Volotovsky had misgivings about signing the consent order, and one can see that in Mr. Duthie's affidavit, paragraphs 53 to 56. For your Lordship's reference, the page is 315, and that led to steps being taken to replace him with Mr. Smith. And Mr. Smith then instructed Mr. Greenwood to sign the consent order on behalf of Mex Securities on the 14th of December 2020. And one can see that on page 226. And that consent order is approved at a hearing before Mr. Justice Wallbank on the same day at which Mex Securities is represented by Andrew Emery. And one can see the terms, my Lords, on page 231. This is the terms of the consent order. And once again, my lords, the claim is unambiguously a debt claim, and your lordships can see that Mex Clearing agreed to assign its claims against VDHAG to Mex Securities. And my lords, strikingly, on the same day, MGWL entered into a deed of indemnity agreeing to indemnify Mr. Smith against any liability he might incur for entering into the consent order. And one can find the deed of indemnity on page 227. Now, my lords, MGWL claim that Mr. Gollitz must have been aware of all of this, but there's compelling evidence to the contrary. On the 15th of December 2020, Mr. Volotovsky sent an email letting Mr. Gollitz know that he was looking for a lawyer to represent Mex Securities, and a copy of that email is on page 234. Of course, that is not accurate. Mex Securities was represented by Andrew Emery at the hearing on the 14th of December 2020, at which the consent order was made.
So you took us to 234.
My lord, yes, that is 234 is an email from Mr. Volotovsky to Mr. Gollitz. In that email, Mr. Volotovsky said that he was looking for a lawyer to represent Mex Securities.
In what?
In the BVI.
That had settled.
Quite. And so the point is, my lord, that MGWL claims that Mr. Gollitz must have been aware of all of this. But in my submission, this is compelling evidence to the contrary, that he was being kept in the dark. My lords, following the entry into the consent order, Mr. Taher sends an email to Mr. Smith asking him to change Mex Securities' name to another name. And Mr. Smith asks him what name he would like it to be changed to. And one can see that on pages 236 and 237. And so there can be little doubt in my submission who's calling the shots at Mex Securities at that stage. On the 18th of December 2020, MBFX pays 36 million euros, well, 36,385,509.52 euros from the note holders' funds to Mex Clearing. And one sees that paragraph 75 of Mr. Duffy's email, which is on page 323. And from the 22nd of December 2020, it appears that Mex Securities undergoes a change of heart. So on the 22nd of December 2020, Conyers writes to MBFX on behalf of Mex Securities, telling them not to transfer any money. Now, of course, by then the money's gone already. But the letter from Conyers is on page 246. 246, my lord. So that's a letter from Conyers to MBFX. Under no circumstances should these funds be removed. They had already. And then on the 6th of January 2021, a Luxembourg lawyer, Mr. Maillet, writes on behalf of Mex Securities, and that letter is at page 255, requiring MBFX to pay over the note holders' funds to Mex Securities. And then about the 2nd of March 2021, Max Maillet sends the Luxembourg summons to Mr. Duffy. And in that summons, it's alleged that Mr. Smith was pressured into signing the consent order and that he lacked any authority to enter into the consent order. And one sees that on page 257. And my lords, this prompts Multibank to obtain an anti-suit injunction in the BVI, and one sees that referred to in the ex parte judgment of Mr. Justice Bryan, which is to be found on page 353, and to seek and obtain a super injunction in England preventing anyone from repeating the allegations in the Luxembourg summons. It is at this point that VDHI discover for the first time that the consent order was entered into. And one sees that from a statement of Mr. Priest, paragraph 36, supplemental bundle, page 2017. And VDHI take the view that the consent order is a collusive document which purported to settle a dispute which did not really exist, in order to enable Multibank to misappropriate 36 million euros of noteholder funds. And this prompted them to apply for and obtain a freezing order against Mex Clearing, Mex Securities and MBFX on the 26th of April 2021. And the freezing orders at page 400. And VDHI was then appointed a representative claimant on behalf of the note holders on the 21st of June 2021, and it issued proceedings in the BVI on the 22nd of June 2021. My lords, the representative party order is to be found at page 416. And VDHI's proceedings are completely different from the Luxembourg summons in that they do not allege that Mr. Smith was coerced. Rather, VDHI alleged that Mr. Smith colluded with Multibank to misappropriate note holders' funds. My lords, there were then various interlocutory skirmishes in the BVI. Mr. Justice Jack refused an application to discharge VDHI's freezing order on the 4th of October 2021, and Mr. Justice Jack's judgment is to be found on page 466. My lords, during the course of that judgment, Mr. Justice Jack referred to the consent order as clearly collusive and suggested that a copy of his judgment should be sent to the Financial Services Commission in the BVI. This prompted MBFX to apply for his recusal, which was refused by Mr. Justice Jack on the 17th of December 2021, and the reference for that is page 548, but it was granted by the Court of Appeal on the 25th of April 2022. And the Court of Appeal's judgment in the BVI is to be found at page 958. In the intervening period, MGWL also applied to have VDHI's representation order set aside on the basis that it was not a suitable representative party. That application was dismissed by Mr. Justice Jack on the 28th of March 2022, and the judgment is on page 751. I'm coming close to the end of the background chronology, my lords, but just a few more points. The first is that on the 11th of May 2022, MGWL fire Mr. Duthie, leading to a dispute which prompted Mr. Duthie to send what we've referred to as the Duthie email, which can be found at page 980. And I'd ask my lords just to turn that up now.
That's what tab?
Page 980, and it's tab, I think it's tab 64, I'll just check.
64.
I think so, my lord, I'll just, 65, my lord, I'm sorry. Tab 65, page 980. So this is an email sent in May 2022, so roughly a year and a half before proceedings are commenced in Scotland. And I'd urge my lords to read the entire email, but for present purposes, could I just refer my lords to page 985 under the heading Muddying the Waters. Mr. Duthie remarks as follows: I know from our last meeting in London that you were trying to beat up a mad conspiracy theory against Michael Gollitz, Colin Smith and Stuart Ford. The theory is that Michael, Colin and Stuart, and probably me too, conspired to take your money from the Alpha Multibank notes and invest it in other products in which they were interested. There's not a scrap of evidence for this nonsense. I know for a fact that Stewart had nothing to do with Colin reneging on the consent order. He did this at the instigation of Slava and the Luxembourg lawyer, but I suppose that will not stop you from commencing the claim. The only reason for doing so would be a distraction. It would be an attempt to muddy the waters in the BVI dispute and put more distance between you and what happened in Dubai in December 2020. Now, that email was very vaguely referred to in the main body of the evidence of the ex-parte hearing, certainly not sufficiently, and it was buried in the exhibits, and that's a separate point that I'll come to. But for present purposes, for the chronology, that is what Mr. Duthie says about a year and a half before proceedings were issued by Multibank in October. So it's clear that Mr. Taha was contemplating his present claim as early as May 2022. And it's also clear that when Mr. Taha says at paragraph 109.5 of his affidavit, which is in the supplementary bundle at page 2203, that he discovered the alleged conspiracy in October 2023, that must be a lie. And my lords, on the 24th of June 2022, MGWL assigns all the claims which it has against VDHI, the alleged claims it has against VDHI, VDHAG and Mr. Gollitz, to MBFX. One can see that assignment at page 993. And MBFX, so this is after MBFX is sued by VDHI, MBFX applies for and obtains permission to join Mr. Gollitz and VDHAG to the BVI proceedings on the 29th of June 2022. And one sees that, my lords, from the affidavit filed in connection with the jurisdiction challenge of VDHAG and Mr. Gollitz, of Mr. McDermott, which is at page 1586, 1586, paragraph 34. And it's noteworthy, my lords, that MBFX's claim against Mr. Gollitz and VDHAG was broadly speaking for alleged breach of the joint venture agreements, the alleged joint venture agreements. That was the claim that MBFX brought in the BVI. And proceedings were then served on Mr. Gollitz and VDHAG on the 10th of March 2023. And one sees that from Mr. McDermott's affidavit, paragraph 47, which is on page 1588. Only for there to be a sharp change in direction when MGWL commenced its own claim against Mr. Gollitz and VDHAG in Scotland on the 18th of October 2023. And my lords, my lords, forgive the lengthy introduction, but there have been a number of points made on the chronology, and no doubt more will be made, but I thought it would be helpful to set out the core run of events because it does relate, it does tie in with the Lavender Marshall application for reasons that I'll explain. So on the meat of the application, I can deal with 2 points very, very briefly, the administrator letter and the FCA letter. As regards the administrator letter, MGWL's position appears to be that the administrator letter is relevant to, and only relevant to, its appeal against the strikeout of its application against VDHI. And on the basis that MGWL doesn't suggest that the administrator letter has any relevance to the appeal as between MGWL and my clients, we neither oppose nor support the application in relation to that document. So the second is the FCA letter. As regards the FCA letter, my lords, the witness statement of Aisha Salim of Howard Kennedy, who were the solicitors for my clients, filed in connection with MGWL's first Lavender Marshall application, addresses the FCA letter and why the full run of correspondence, which was not initially offered as part of the application, but which we had to ask for, in fact shows that the FCA regarded MGWL to be in breach of sections 19 and 21 of FISMA. And for your lordship's reference, that's set out in Ms. Salim's third statement, paragraphs 22 to 28 and 38 to 39, and that's to be found in the Lavender Marshall bundle tab 4, pages 29 to 31 and 33. My lords, to cut through it, the parties were agreed, subject of course to the court, that the FCA letter and its associated correspondence may be considered by the court. And I don't propose to address your lordships further on what the correspondence shows at this stage. I'll make submissions on these documents in the context of the substantive appeal. I just want to say a few words about the law, if I may, before turning to the Scottish documents and the Scottish judgments. We have referred to the very recent, relatively recent Court of Appeal decision Al-Sadek and Deshet, which is in the Ladden Marshall Authorities bundle. And that is at tab 9 of the Ladden Marshall Authorities bundle. The short point is, as the Court of Appeal there explained, paragraph 141, this is the judgment of Lord Justice Popplewell. Paragraph 141, internal pagination 211. This court has a discretion under CPR 52.21 2b to receive evidence on appeal which was not before the lower court. The well-known test in Ladden Marshall continues to provide important guidance as to the exercise of the discretion. Although the discretion is not confined by it, evidence may be admitted where the test is not fulfilled or not admitted where it is, if either is dictated by furtherance of the overriding objective. And then obviously onto the Ladden Marshall test at 142. New evidence will be allowed on appeal if there are 3 conditions fulfilled. Evidence could not have been obtained with reasonable diligence for use in the first instance. If given, the evidence would probably have an important influence on the result of the case, though it need not be decisive. And 3, the evidence is such as presumably to be believed. Now, before I turn to the Scottish documents, I just want to say a few words about the background to the Ladden Marshall applications, because they are relevant. And we raised 2 arguments that are separate to the importance of the alleged importance of these documents, which are flagged at the end of our skeleton argument, which I'll come to. But just on the background, my lords, my clients, what are referred to as the HK defendants, oppose MGWL's application to rely on the Scottish documents on 3 grounds. First, the Scottish documents would not have had an important influence on the result below, and/or they do not amount to new evidence. Secondly, the application, if granted, would create unfairness in the appeal. And thirdly, the application has been made in an unfair and oppressive manner. And my lords, before turning to the question of whether the documents would have had an important influence on the result below and/or whether they amount to new evidence, I'd like to say a few words about the background to the application insofar as it contains these documents. So MGWL first filed its notice of its first application, which accounts for all but 8 of the Scottish documents, on Thursday, the 27th of June. In breach of CPR 23.71a, they waited until 1:30 on Friday, the 28th of June, to serve it on the HK defendants without explanation or apology. My lords have seen the size of the non-cause supplemental bundle. I'm sure that the court can well imagine that given the scale of this appeal, the unheralded application to rely on 222 pages of fairly dense documentation meant that immediate work was required to respond to that application without prejudicing the preparation of the appeal. The difficulty, and my lords have been taken to Mr. Hastings' first statement in support of the application, was that almost no information as to why any of the 68 documents relied upon, no information was given, almost no information was given as to why any of the 68 documents relied upon would have, on MGWL's case, had an important impact on the decision below. And my clients responded to the application by way of a letter on Monday, the 1st of July. If I could just ask my lords to turn to that. It's in the Ladden Marshall bundle, tab 5, page 71. So this is within a few working days of receiving the application. Those instructing me write a letter, and I'll just pick it up at the bottom of page 71. Documents received as a result of the Scottish search order. So how can he say this? Your clients seek permission to rely upon 68 documents received as a result of the Scottish search order running to 222 pages. You assert that these documents would have had an important influence on the court below, but offer no particularised explanation of why this is the case. Instead, you only offer a list of points at paragraph 43 of Mr. Hastings' witness statement to which the documents are said to be relevant, without explaining why any particular document is said to be relevant to any particular point, or why the points in question were important to the judge's decision, which in some cases is not obvious. It is unsatisfactory for your client to dump 222 pages of dense documents upon us in the run-up to a lengthy appeal and expect us to guess at why you say that they would have affected the outcome of the hearing below. We're concerned that you've done this because you yourselves haven't properly considered the documents yet and only plan to conduct any real analysis when formulating the submissions promised in paragraph 44 of Mr. Hastings' witness statement. Had you properly considered the documents, it would have been impossible for you to have asserted, as you have, that the document at page 67 of MRH3 could not have been relied on in the court below in circumstances in which your client did in fact obtain it and rely upon it in the court below, exhibiting it to Mr. Yahya Tahir's first affidavit. It can be found at, and that's an old bundle reference, of the bundle before Mr. Tinkler. Nor do we see how your assertion that it would have had an important influence on the court below can be reconciled with the fact that so far as we can tell from a brief review, your client didn't refer to it in written or oral submissions once, the judge didn't refer to it once, and the various authors of your client's various appeal skeletons didn't refer to it once. I should just pause, my lords, by making the point that in the letter we say the two copies are identical. We've since identified very minor differences that aren't picked up on in the application. So very materially the same document. But there are some minor differences.
That's the investment opportunity document.
Yes.
Isn't it?
No, it's the document. The documents. The original document, if you like, my lord, is exhibited to Miss Salim's statement, and it's tab 5, page 39. So that's the old document, and the new document is to be found. It's document 17, which is addressed in my learned friend's table, page 223.
223.
My lord, yes. Yeah. And so,
Are there
there
any
are,
other documents that had been in the original bundles that are in this?
no, not as far as I'm aware, my lord. And as I say, there are very minor differences, but those differences don't form the basis upon which it's said that this document. It is, my lord. But that was the document that we referred to in our letter and in the letter from those instructing me. And we asked for proper notice of reasons. So on page 72 of the letter from Howard Kennedy, in order to ensure that our client has proper notice of the reasons why you say that each of the documents on which you seek to rely would have had an important influence on the court below, we ask you to complete the table attached to this letter and return it to us by no later than 4 p.m. on Friday, the 5th of July, 2024. My lords, MGWL didn't respond, even by way of a holding response, by 4 p.m. on the 5th of July 2024. Instead, it replied at 9:07 p.m. on the 8th of July 2024 with a brief letter enclosing the wider run of correspondence with the FCA and stating that no further details of MGWL's case in relation to the Scottish documents would be provided in advance of its skeleton, which it said would be served later this week. And that letter from Quillen is in the Ladden Marshall bundle, page 78, so tab 5, page 78. And that same letter indicated that MGWL was considering making a further Ladden Marshall application in respect of some further 38 documents. And contrary to the assurances in MGWL's letter of the 5th of July 2024, no skeleton was served during that week. In the interim...
Letter of the 8th of July. You just quoted a letter.
I'm sorry. The letter of the 8th of July. No skeleton was served during that week. In the interim, the HK defendants set out their position in relation to the application by way of the statement of Aisha Salim, which my lords have in tab 4, page 26. And that was served on MGWL on the 10th of July 2024. And my lords, in that statement, the HK defendants observed that MGWL's refusal to explain why it thought that the Scottish documents would have had an important influence upon the judge only had two possible explanations. Either MGWL had no clear idea itself why the Scottish documents would have had an important influence, or MGWL did have a case as to why the Scottish documents would have had an important influence but were keeping it back for tactical effect. on Monday, the 15th of July 2024, so last Monday, at 1:30 in the afternoon, MGWL set out its case in a 31-page skeleton accompanied by a 17-page table and an application to rely upon a further 8 Scottish
Well, leaving
documents.
aside the timing, the schedule to the skeleton argument actually provides the answers to the question that the proposed table that your solicitors have put forward that we've got at page 72, is it 73?
My lord, yes, I'm going to go to
It
that.
actually has the 2 columns, issues to which the document is said to be relevant, and reasons why the document would have had
My lord, yes.
an influence on the court. So you've got the answers. I mean, I follow the point. You didn't get any sort of answer until a week ago today. But the fact is you did get an answer.
My lord, we did, very late. So by Monday last week, when we finally received their skeleton argument, since they got the 93 documents on the 19th of June, they'd had 3.5 weeks to cogitate and articulate their position. We were effectively given a matter of days to respond. I'm going to go to the table first to address your lordships on the explanations that have been given to us about the relevance of these documents in the table.
If we're going to be looking at that, could I please have from somebody a hard copy of the Claimant skeleton?
I think
you might have found that
this-
one of the many
Brandon,
files
is it-
that
is
appear
it
to have
on
been
left?
placed on the bench.
the one that's on top of the computer there.
Oh, right.
I think that's it.
Oh, fantastic. Thank you very much.
Special surprise for your lordship.
My lord, just before I turn to the documents in the table, I just have a few more points. So we've had no explanation of why the delay. And as regards the documents
I
themselves,
think I did give quite a clear explanation, in fact. Made it quite clear the kind of pressures we were under and trying to assist the court.
Well,
in that
you've
manner.
made the points about timing. That's why I said, subject to timing, you've got the explanation in the schedule. Now, you could, one or other, you could have applied for this appeal to be adjourned, or for this application to be adjourned, and for the matter to be dealt with on another occasion. But this is all just about timing at the moment. I mean, what? As far as I'm concerned, Mr. Calfan, what I'm really interested in is on what basis you say either that this doesn't fall within the Ladd and Marshall test because I asked you the question, have they got it from somewhere else, or could they have got it from somewhere else? Or alternatively, that you've got a cogent case that it actually doesn't amount to a row of beans, if I can use it colloquially.
yes. Well, I'll go straight
That's
to that.
effectively
Yes.
really
Well,
the 2 points we're interested in.
I'm
I
great.
mean, lots of sort of shadow boxing about who said what to whom and when doesn't really help this call.
No. Well, my lord, I make one point, which is this, and I'm going to come back to this. But MGWL there's conflicting evidence on this, but MGWL have either received 12,200 or 13,000 documents in Scotland. They're not from us, and we've not seen those documents. The only documents that we've seen are the ones that they've picked for the purpose of this application. I'll come back to that point. Now, as regards the documents in the table, so MGWL don't even address all the documents in their schedule. They deal with some simply in tabular form, and in a very schematic way. And we've responded to each document in the table, in our own table, which is annexed to our skeleton argument. And of course, my lords, each document needs to be considered on its merits. And my lords, I'm not going to take you through each entry, but I would just make a few points. So as your lordships will recall, in our letter of the 1st of July 2024, we explained that it was unsatisfactory to leave us guessing. And we referred to the NPL presentation, which was almost identical to a document that was before the judge. And that is to be found in the table at document 19. And my lord, so MGWL, despite us saying that this is almost an identical document, and it wasn't referred to it wasn't referred to below, MGWL have seemingly maintained their position that the almost identical document is one that would have had an important influence on the decision of the court below, because it's in the table. And the alleged reason why this document is said to be important, according to item 17 in the table, is because Mr. Gollitz appears on CSM promotional material as the managing director of the independent wealth management firm DHCJ, misrepresenting Mr. Gollitz's independence from CSM.
Sorry, where are you reading from?
So I'm taking the explanation from their table
Yes.
in relation to document 17.
Document 17.
which is the one that's virtually identical to the document that was before the judge at first instance, as the first example.
CSM US Consumer Loans Presentation.
Let me just check I have that.
Yeah.
Yes, and so the explanation that's given as to the alleged reason why it's said to be important is Mr. Gollitz appears on CSM promotional material as the managing director of the independent wealth management firm VDHAG, misrepresenting Mr. Gollitz's independence from CSM. My lords, exactly the same wording appeared in the version of the document which appeared before the judge, and MGWL have made no attempt to explain why it's so important now when it wasn't before. Indeed, it would be open to them to ask to have a copy of the old NPL presentation included in the supplementary bundle if they suddenly regarded the words independent wealth management firm as important. And we would have acceded to such a request, but they've not done so. Instead, they maintain their Ladden Marshall application in respect of an almost identical document. And my lords, and I'll come on to further examples, but this demonstrates that MGWL is prepared to maintain its assertions that documents are important to the decision below when there is simply no support for that proposition. And the court can and should have no confidence in the contentions regarding these documents, and unfortunately has to scrutinise with care the document itself and the alleged issue it is said to go to. My lords, we've endeavoured to assist the court with individual responses to all of the documents which are relied upon by MGWL. And what this document self-evidently does not do is to evidence Mr. Gollitz was not independent, which presumably comes back to the idea that he had a concealed financial interest in CSM, something to which I'll return. And before, my lords, turning to the documents addressed in MGWL's skeleton argument, I don't think Mr. Grant took you to one document on the table. I may be mistaken, or certainly one document that's only dealt with in the table. But before going to some of the documents that are addressed by my learned friend in the main body of the skeleton argument, I'd like to give just one more example by reference to the table. My lords, there are a collection of documents that, according to MGWL, would have had an important influence on the court because they consist of, quote, extensive communications regarding the movement of money between VDHAG, CSM, and CSM's alleged founders, Mr. Smith, Mr. Ford, and Mr. Gollitz. So, for example, documents 37, 39, and 40. I think there may be others. Now, just staying with those three documents, as it happens, document 40 doesn't show any movement of money between the people claimed. But my lords, the reference to movement of money could, particularly to those not familiar with the case, give the erroneous impression that there is something necessarily nefarious about that. My lords, as Mr. Gollitz explains in his second witness statement, so this is the statement that was before Mr. Tinkler, and as Mr. Tinkler was well aware, CSM is a securitization vehicle founded in mid-2020, and this is, for your lordship's reference, set out in Mr. Gollitz's second statement, paragraphs 27 to 29, which is to be found on page 2037. I think it's tab 107. So CSM is a securitization vehicle founded in mid-2020. It issues bonds and uses the proceeds to acquire various alternative investments, the returns from which are used to fund payments to the bondholders. VDHAG has invested a small portion of its client money into CSM's bonds and also manages some of the funds invested by third parties into CSM, all of which VDHAG earns fees on. This was all the evidence before Mr. Tinkler. The fees referable to investments in bonds issued by CSM and the management of CSM's assets are charged on VDHAG's usual fee scale. So, my lords, the mere fact of monies moving to or from CSM does not give rise to any adverse inference. To be clear, my lords, what none of the documents cherry-picked by MGWL shows is any movement of monies evidencing a bribe or what has been called a concealed financial interest of Mr. Gollitz or VDHAG in CSM. And my lords, as I say, we've responded to each document in the table, and I'd invite my lords to consider each of our responses to the documents set out in the table. What I'm going to do now is move on to some of the documents that are given prominence by being addressed in in the main body of their skeleton argument. So dealing with MGWL's skeleton argument, my lords, at paragraph 56, of its skeleton argument, MGWL makes 4 claims in relation to CSM. And we can turn these up actually by reference to our skeleton argument, my lords. So the HK Defendants skeleton argument at paragraph 36. So MGWL's first claim in paragraph 56, subpara 2 of its skeleton, is that documents 4, 5, 6, 7, 8, 9, 10, 11, 14 and 32 show that Mr. Gollitz was lying when he said, quote, "Neither I nor VDHAG have any stake in CSM. We have no economic interest in it, nor do we have any control over it. CSM does not stand for Column Stewart Michael. Mr. Smith told me that the name is an in-joke. It stands for Column Smith, square brackets, multi, close brackets, assets. VDHAG has invested a small portion of its client money into CSM bonds, and it also manages some of the fees referable to investments in bonds issued by CMS. So again, my lords, we deal with these documents individually in our skeleton argument in the order put forward by MGWL. Before doing so, we say in our skeleton argument at paragraph 36 that it should be noted that Mr. Gollitz was entirely frank in the court below that at one point arrangements were put in place for him to receive a personal fee in respect of monies invested in CSM, but that such fees were never paid. And that is to be found in the supplementary bundle at page 2295. I'd ask my lords just to turn that up very briefly.
Two 2295.
My lord, yes.
That's his third witness statement.
Yes, dated the 7th of December 2023. And one can see at paragraph 30, so this is before the judge below, Mr. Tinkler. As for the allegation that I own commission from CSM which are paid to companies in England, I do not know what Mr. Nasatahe is talking about. The only thing I can think of is that at one point there was an agreement that I would receive distribution fees on a range of products, including CSM products from the 7th defendant, and that's Regal Consultancy International Limited. It may be that Nasatahe is somewhere aware of that agreement. However, that agreement was never performed. Such distribution fees have never been paid nor requested by me, so far as I'm concerned, I'm remunerated by my salary and I do not desire commissions from elsewhere. Not that there would have been anything inappropriate with me taking any such commissions. And my lords, none of the documents upon which MGWL seek to rely contradict that statement. None of them shows any commission. My lords, just turning to document 4, which my learned friend Mr. Grant took the court to, and I'd just like to go to that again. So that's in the Ladden Marshall bundle, tab 9, page 173. So this document, there's a document attached to an email of the 7th of May 2020, over 4 years ago, which contains a structured chart which shows on page 177 that CSM is 100% beneficially owned by Colin Smith, and that VDHAG's sole interest in CSM is fees, and one can see that also the middle arrow at the bottom pointing to the right. And my lords, MGWL attempt to rely on 2 statements in document 4 to wring greater significance out of it. The first, and we can see this, my lords, picking up paragraph 40 of our skeleton argument. So the first is the statement, quote, VDH can distribute management fee portions to founders Colin, Stewart and Michael based upon terms to be agreed. Now, as to this, And Mr. Gollitz has provided, not forgetting, my lords, that we received the explanation finally for these documents on Monday last week. Mr. Gollitz has provided an explanation in paragraph 8 of his 5th statement. He says he doesn't know why Mr. Smith used the term founder. It may be because at one point it was envisaged that Mr. Gollitz would be a part owner of CSM, but that plan was abandoned. He says whatever Mr. Smith contemplated in May 2020, management fees from CSM were never shared between Mr. Smith, Mr. Ford and Mr. Gollitz via VDHCJ. And again, my lords, none of the documents upon which MGW seek to rely show the contrary. The second is the statement, and one can pick this up again from our skeleton argument at paragraph 41, which is this: for the purpose of bank due diligence, Colm Smith appears as and declares himself to be the beneficial owner of CSM Securities SAR. And this is said to show that the intention was to misrepresent the ownership of CSM to its bank, EDB. As to this, it has selectively quoted from the relevant passage. If we go to page 175, it actually reads, the investors are the economic beneficiaries of CSM Securities SAR through their rights as note holders. For the purposes of bank due diligence, Colm Smith shall appear as and declare himself to be the beneficial owner of CSM Securities SAR, i.e. the distinction is between the note holders, who will ultimately have the interest in CSM's assets, and Mr. Smith, who is the UBO in the sense that he holds all the shares and must be declared as such for due diligence purposes. So, my lords, the distinction is not between Mr. Gollitz, Mr. Ford and Mr. Smith, on the one hand as real beneficial owners and Mr. Smith as ostensible owner. And my lord, this is confirmed by the structure chart 2 pages further into the presentation, which, as I've shown, my lords, shows a large arrow pointing to CSM, labelled UBO, Colm Smith, 100% of shares. And my lords, given that MGWL's case is that document 4 sets down what Mr. Smith contemplated being the true position, it must be accepted that the chart shows the arrangements which he actually intended to put in place. And furthermore, my lords, the evidence is that the presentation was actually sent to EDB, which I think is the European Depository Bank. So the suggestion that the presentation discloses some plot to deceive EDB is a nonsense. And this is important, my lords, because in MGWL's skeleton argument, one of the allegations made by reference to these documents is that there's now evidence of Mr. Gollitz having conspired to, quote, conceal information from and present a false picture to banks. And that's said at MGWL's skeleton argument, paragraph 5, subpara 2. My lords, in fact, the documents demonstrate nothing of the sort. So this emerges from the following. The first page of document 4 is an email from Mr. Smith to Mr. Ford and Mr. Gollitz on the 7th of May 2020, in which he says, please see attached the presentation and deed of incorporation for the new issuer. Document 7, which starts on page 190 of the Lavender Marshall bundle, consists of an email chain commencing on page 192 and then continuing to an email from Mr. Smith to Mr. Gollitz on the 13th of May 2020, which is on page 191, in which he says, I've sent an application to EDB to open the bank account to start the incorporation. That included the deed of incorporation and the PDF presentation. My lords, the clear implication being that the deed of incorporation and presentation are the same as those earlier in the chain, so document 4. And my lords, that implication is confirmed in document 5, which shows EDB, if we go to page 182, it shows EDB asking questions which are clearly referable to the terms of the presentation. For example, EDB puts in quotes, underlying assets will be held at EDB. That's at 182. That quote is clearly from the box in the bottom right of page 22. Again, at page 122, they list the portfolios which CSM will invest in. The first 5 are clearly the first 5 listed on page 175 of the presentation. Now, one of them is different which suggests that the draft might have moved on, but there's no reason to think that the founder language has been removed. My lords, I should also say that it's noteworthy that MGWL have only put forward one of two attachments which were attached to the email in document 4. The other attachment, which was a deed of incorporation, is exhibited to Mr. Gollett's 5th statement. And that's at page 525 of the hopefully updated Loudon Marshall bundle, but it's exhibited at page 1, I think, of Mr. Gollett's 5th statement. And that is a deed of incorporation. And reviewing it, it's clear why MGWL filtered it out from the selection of Scottish documents which it seeks to place before the court, because it lists the sole shareholder as Mr. Smith and no one else. And that's to be found on page 541, if my lords have the updated bundle, which includes Mr. Gollett's statement and the exhibits to Mr. Gollett's statement. And my lords, if Mr. Gollett's really were lying when he said he had no economic interest in or control over CSM, one would have expected, amongst the thousands of documents searched for by MGWL, which we've not had sight of, some evidence of him exercising control over or receiving the benefits of an economic interest in CSM. There is nothing other than a fee agreement, which I'll come to, the existence of which was volunteered at first instance. Now, my lords, turning to document 5, MGWL claims that document 5 shows Mr. Smith lying to EDB when he says that CSM has no significance, it's my initials with the letter M managed at the end. My lords, as to this claim is based on the assertion that the phrase, "For the purposes of bank due diligence, Colm Smith shall appear as and declare himself to be the beneficial owner of CSM Securities, SAL," betrays a plot to deceive EDB. And for the reasons that I've explained, it does not. The PDF presentation went to the bank. Once this is recognised, there is no reason to disbelieve Mr. Smith's assertion to EDB on the 13th of May 2020, many months before the dispute in question arose, that CSM has no significance, it's my initials with the letter M managed at the end, a position which is substantially the same as Mr. Gollett's evidence, which I think your lordships have been taken to, but for reference, it's the second statement, paragraph 28, page 2037, and third statement, page 2291. My lord, the second claim that MGWL make in their skeleton argument at paragraph 56.3 is that document 7 shows that Mr. Gollett's, Mr. Ford and Mr. Smith were considering diverting funds from the notes issued by Mex Securities into CSM. And this is addressed in paragraph 50 of our skeleton argument. The basis of the allegation is a statement by Mr. Smith sent at 12:24 on the 11th of May 2020, in which Mr. Smith said, "Hi Michael, can you send me the term sheets for the Oaklet products to bring in to CSM?" That's document 7. Page 192. And my lord, that allegation is wrong because Mr. Smith is not referring to the notes, but to different Oaklet products. He explains this in his witness statement at paragraph 11, his 5th witness statement, but it's substantiated by document 4, which refers to 3 identified Oaklet products being put into CSM. So if one turns to page 175, one sees Roman numerals 1, 2, and 3. Property portfolio currently structured through Oaklet. Active portfolio an activist stock portfolio of small and mid-sized listed companies structured through Euclid, US stocks algorithm strategy portfolio structured through Euclid. None of these are Mex Securities notes. So the allegation, the very serious allegation made, that this shows that Gollitz, Ford and Smith were considering diverting funds from the notes issued by Mex Securities into CSM is simply wrong, and can be shown to be wrong by reference to the documents themselves. My lord, the third claim is the supposed lie as regards Mr. Ford's status. And so MGWL's third claim, which is at paragraph 56, subparagraph 4 of its skeleton argument, is that documents 4, 5, 62, 64 and 65 somehow show that Mr. Gollitz was lying when he said that his understanding was that Mr. Ford had complied with his lifetime ban imposed upon him by the FCA under section 56 FISMA 2000. Obviously he makes that statement in his second statement that was before Mr. Tinkler. One can see that, paragraphs 24 and 31, page 2037. Now, under the terms of that ban, Mr. Ford is not to perform any function in relation to any regulated activity carried on by an authorised person, exempt person or exempt professional person. And the Ford and FCA decision is not in the bundle, but for the court's reference, one sees that at paragraph 687, subpara 1 of Ford and FCA 2018 UK U2 UT 0358. The references to regulated activity and authorised person are references to activities regulated and persons authorised by the FCA. The FCA obviously cannot and hasn't banned Mr. Ford from doing anything outside the FCA's jurisdiction. The suggestion that any of these documents shows that Mr. Gollitz thought that Mr. Ford might be acting in breach of his lifetime ban faces 4 difficulties, which we've set out to paragraph 52 of our skeleton argument. First of all, my lords, it presupposes that Mr. Gollitz, who's not an English lawyer and is not subject to the English regulatory regime, would understand what Mr. Ford was and was not permitted to do under UK financial services legislation. Secondly, if MGWL is to maintain a case that Mr. Ford was breaching his lifetime ban and Mr. Gollitz was aware of that fact, it is incumbent on MGWL to identify the function which Mr. Ford is said to be carrying out, the regulated activity in relation to which he was carrying it out, the authorised exempt or exempt professional person carrying on the regulated activity. Simply asserting that Mr. Ford is carrying on regulated activity through CSM is not good enough. Not least because there is no evidence that anything which CSM did was regulated by the FCA. And this point was made, my lords, in submission below, and I'd refer, my lords, I won't take the court to it at the moment, but paragraph 70, subpara 1 of our skeleton argument before Mr. Tinkler, which is in the supplementary bundle, page 2694. And MGWL conspicuously declined to advance any particulars on its case on the point. Thirdly, my lords, as MGWL is aware, Mr. Ford was in receipt of draft opinions from leading counsel to the effect that he could act as a general business consultant and strategic advisor to entities issuing regulated securities. Those drafts appear to have been attached to document 47, which is tab 9 in the Ladden Marshall bundle, page 318. And one can see, please find enclosed 2 draft opinions in this matter. But my lords, consistently with its approach in relation to document 4, where one of the attachments was excluded, MGWL has not put forward attachments to emails which it regards as unhelpful to its case. Fourthly, my lords, none of the documents in fact suggest, and that's why we've been through each one giving our individual responses to each document, none of the documents in fact suggest that Mr. Gollitz did think that Mr. Ford was violating his lifetime ban. My lords, the fourth claim that MGWL make in their skeleton argument is that Mr. Duthie was providing legal assistance to Mr. Ford. And one sees that in paragraph 56, subparagraph 5 and by reference to document 24, tab 9 of the Lavender Marshall bundle. Page 277. My lords, as we say in paragraph 53 of our skeleton argument, this is very old news. The fact that Mr. Duthie provided legal services to Mr. Ford is recorded in the passage of the FCA tribunal judgment on which MGWL erroneously relies to advance its case against Mr. Cormack. That obviously was before Mr. Tinkler, and the reference for your lordships is supplementary bundle, tab 5, page 50. My lords, turning to the documents that are said to go to the control of Mex Securities.
I want to just make one point, my lords, because I don't want to be unfair to my learned friend. Your lordships will have heard that I made very substantial submissions that Mr. Gollitz's witness statement of paragraph 31 made demonstrable untruths about Mr. Ford's involvement. I think my learned friend might want to deal with that point, because if he doesn't, I'm going to make submissions in response. Paragraph 31 of Gollitz 2, look at the documents and you'll see the demonstrable untruth is my submission.
I think we should, it's gone 4:15. I think we probably all had enough for one day. I am a bit concerned. We seem to spend the entire day on the Lavender Marshall application. We haven't got anywhere near the end of it by the look of it. And we have a substantive appeal to deal with. And it is simply not possible for this court to sit beyond 4:15 on Wednesday. So you are both going to need to cut your cloth accordingly. 10:30 in the morning, please.
Court rise if able.